This is kind of you don't see, like, ever. The integrity of a verdict has got to be maintained. Otherwise, anybody can be convicted of anything. This comes through, like this motion says, it's a new trial. There's no question it's a new trial.
Bruce Rivers, he's the criminal lawyer. Who is he? Bruce Rivers, he's the criminal lawyer. And who is he? Bruce Rivers, he's the criminal lawyer. And what he do? And it's gonna react to all the self-snitching.
Hi, this is Bruce Rivers. Welcome to another fun-filled episode of Criminal Lawyer Reacts. I'm Bruce Rivers, board-certified criminal defense lawyer, coming to you with my pearl handle pistol cufflinks, so graciously gifted to me by our content genius, Michael Rivers, who not only is behind the camera, but behind every idea, everything we do, every waking hour I spent thinking about my son. No, not really quite that obsessive-compulsive, but he is just an amazing guy, and so today we're going to react a little bit to the defense motion to that that the Murdaugh team has filed. In this case, it's really interesting, and so we're going to watch their press conference and kind of go through what this means and see if he's going to get a new trial or what it means. But before we get to that, this episode is brought to you by ContractsCounsel.com. ContractsCounsel.com is an effective way to get a contract written, any kind of business agreement, any kind of contract you think you need a little extra help written. It's they're a good outfit. They're part of eSign.com. We need lawyers. So if you're a lawyer, and I know some of my fans are lawyers, and you'd like to do some work from home remotely, as much or as little as you want, you can sign up for ContractsCounsel.com. We got a lot of clients, and we need a lot of lawyers. So if you are a lawyer and you're looking for some remote work, you can do it with ContractsCounsel.com. They're a good outfit, like I said, affiliated with eSign.com. And so sign up ASAP because we need your help. Now let's just recap a little bit of the Murdaugh trial. Alec Murdaugh was a lawyer, a disgraced lawyer who was on drugs and doing all kinds of other stuff. And he was stealing from clients like nobody's business. I can't remember the exact amount, but I think it was like $4 million, or I can't remember the exact amount, but it was such outrageous. You know, the lawyers are entrusted with their clients and in their clients' funds and their clients' lives. So it's just a travesty when that kind of stuff happens. That being that as it may, he was accused of and later convicted of killing both his wife and his son. Now the defense has filed a motion for a new trial based on new evidence. So let's take a look at the press conference.
Today, Jim Griffin and I filed a petition based on newly discovered evidence with the South Carolina Court of Appeals to stay Alec Murdaugh's appeal while a hearing is held on a motion for a new trial.
So here's the procedural posture of a case like this. So they had the trial, they lost. And you only have so many days to file your notice of appeal. In Minnesota, it's like 90 days. And so you file your notice of appeal. And while that's pending, if anything else comes up, you can stay your appeal and have a post-conviction motion. And in this case, they filed a motion for a new trial. And so that's the stage that they want to stay the appeal. That means they hold it in abeyance until they get the trial court to rule on their motion for a new trial.
Concurrently, we've sent a request to the South Carolina U.S. Attorney to open a federal investigation into the violation of Alec Murdaugh's civil rights. The allegations in the petition filed today speak for themselves, but we believe they explain a number of peculiarities in the 6-week trial. We request that SWED stand down on initiating any investigation of these allegations since they are heavily invested in maintaining Alec's convictions.
SWED is the law enforcement agency that was responsible for investigating this case.
Suggest they wait for the Court of Appeals to rule and receive direction from the trial court. If the Court of Appeals remands the case for an evidentiary hearing, if the Court of Appeals remands the case for an evidentiary hearing, we would also request that those in the media and the public respect the privacy of those included in this filing. Jim and I want to thank those on our team who stand behind us and have worked tirelessly to ferret out the truth. Alec Murdaugh maintained and still maintains his innocence in the murder of Maggie and Paul and believes the truth will ultimately prevail.
So let's just say, for the sake of argument, that he is innocent. What a travesty it would be to have an innocent person on 2 life sentences. But once we get into the allegations, what these allegations are, they're unconscionable. And I think it's just absolutely, whether it's enough to grant them a new trial, that's another thing altogether.
Jim?
The right to a jury trial, is a fundamental principle of our justice system. Jurors must be free from outside influences and must decide the case solely on the evidence presented in the courtroom, subject to the rules of evidence, subject to the rules of the court, and, most importantly, subject to the crucible of cross-examination that's guaranteed by the Sixth Amendment to the Constitution, and that is the right to confront witnesses. When jurors receive private communications outside the confines of a public courtroom, the Sixth Amendment is violated and numerous other constitutional rights are violated.
So basically what he's saying is that, no one's supposed to have any contact with the jury about anything substantive unless it's like lunch, if they have a question, or if they have to go to the bathroom, that kind of stuff. And I think the allegation is that the clerk had some communication with this jury that was outside the norm.
That's not Jim Griffin on the law. That is the law of the land. And I want to quote from a decision from the South Carolina Court of Appeals, which is behind me, and states this: where there is a private communication of a court official to members of the jury, an occurrence which cannot be tolerated if the sanctity of the jury system is to be maintained, a new trial must be granted unless it clearly appears that the subject matter of the communication was harmless and could not have affected the verdict.
Now, my understanding, and we'll get to this in a second, but my understanding is that the communication from the clerk was you're not going to believe his bullshit, or not like that exactly, but you're not going to buy what Murdaugh is selling, basically to disregard his testimony.
What we had filed today, supported by sworn testimony of jurors, is that the Clerk of Court had improper private communications with the jurors, and the subject matter of those communications was the credibility of the defense that the Murdaugh legal defense team put up, and it was the believability of the defendant's own testimony. Now, there's been a lot of talked about whether Alex should have taken the stand. I can assure you, when we considered what factors and what we should and should not do and considered whether he should take the stand, we never considered the likelihood, as reported to us by the jurors, that the Clerk of Court would go in to the sanctity of the jury room before he testified and tell the jurors, don't be fooled by his testimony, watch out for his body language, and that is what the sworn testimony that we have filed in court today says.
Let's just unpack that for a second. Before their client testifies, the Clerk of Court goes in and poisons the well. I don't think you can say under any construction that is harmless error at all. And what is harmless error? Harmless error is where you go in and you say, well, that witness, was excluded, but there was so much other evidence that it's a harmless error. It was an error, but he would have been convicted anyway, even with that testimony. That's kind of what a harmless error means. But I think this shocks the conscience so badly that I don't know how you don't get a new trial out of this.
And if that is true, which we have every reason to believe that it is, and no reason to believe that it's not, there's no choice but the courts to grant a new trial.
Thank you. Any questions? No?
Any questions? No, we don't have any questions. He did it. No. But he's right. He's 100% right. The integrity of a verdict has got to be maintained. Otherwise, anybody can be convicted of anything. And what does it mean if he gets a new trial? If he gets a new trial, it just means they start all over again. They've got a preview of what it would look like, but they ask for a new trial, and if they get one, they start all over.
I was there. I watched it. But, look, we were not looking to impute any nefarious conduct. But clearly what the jurors reported to us that they were off talking, the forelady and the clerk. I saw them together, but I wasn't watching. I believe. Look, I've been doing this almost 50 years.
That means you're probably at the end of your game too. You've been doing this 50 years. Kidding. But here's the thing: when you, as a lawyer, you're in the courtroom. You're doing so many things. You've got witnesses. You're writing notes. You're talking to your client. You're talking to your colleagues. You've got other business that you're attending to. There's so many things that you're doing, and so it would be super. And it wouldn't be uncommon to see other court staff around the jury. So to be able to say, oh, there's something nefarious going on is very difficult, and it's difficult to pick up.
The bedrock of any trial, and I've done hundreds of them, is that the clerk of court is the person that makes sure the jury gets their food. If they're put up for the night, someplace to stay, their travel accommodations are met. They're not someone that ever should talk to them about the case.
100% correct. 100% correct on that. And to do otherwise is to tamper with a jury. And it's criminal. To do that is criminal.
I've never had it happen. Again, I've been doing this for a very long time. Never heard of it happening until this case.
And one thing we want everyone to understand, that the clerk of court is an elected official by the people, not appointed by the judge, not appointed by the judiciary. It's a public official who's elected and is an independent state actor. And so what we are complaining about in the motion that we filed today is the conduct of an elected official, not conduct by Judge Newman or anybody in the unified court system.
And I think it's important also to understand that she is a state actor, and that's why we forwarded today a letter to the U.S. Attorney asking them to open an investigation into the violation of Alec Murdaugh's civil rights by a state actor under color of state law.
That just means that somebody was acting in their capacity as a state employee, basically. And one could argue that she was not acting as a state actor in that moment. I mean, she certainly was, because she has the gravity of the office of the clerk of court behind her. But talking to the jury like that is not one of their duties at all. And the reason that's important is because there's no qualified immunity for her for that.
So immediately in the aftermath of the verdict, we had received information that we needed to look into what happened in the jury room. We started down that road, and we met a zone of silence. No jurors would speak to us. And so we were, what I like to call, we were given the Heisman, right? And then when the clerk of court wrote her book, published her book, that zone of silence collapsed. And jurors were upset about that, the ones we talked with.
I've never heard of a clerk of court writing a book about a case in which they were the court clerk. I mean, that's another trust. I mean, you have public trust. I'm shocked about that.
And they were more than willing to come forward and tell us the things that we had sort of heard through a whisper campaign, but and so as a result of that, we were able to interview some jurors. Now, there's still a number of jurors who maintain that zone of silence, who have not talked to us. We did try to reach out to most all of them that we could get in touch with, but the information we got, I can tell you, was independent of each juror. The first juror we talked to, we got information about Ms. Hill saying, "Don't be fooled." And then the second juror, independent of the first juror, says the same thing, and the third juror, independent of the other two, say the same thing. And so we're very confident that the information is accurate.
Well,
and expectation timeline. What a ruling will be? How fast do you want?
Ask them. I mean, we don't have any control over that.
So you file your motion, the opposing side files a response, then you probably get a reply to their response, and then you go have your oral argument. I don't know how if this is true and it affected the jurors, because they're going to probably have to take the testimony of the jurors. This is huge. It's absolutely huge. And you talk about a new trial. What's a new trial going to look like? I mean, probably a lot like the old one, but they have a lot more prep that they've already done.
We just did receive a notice from the Court of Appeals that the Attorney General has 10 days to respond to our motion. Okay? Now, I think what's interesting to me, again, having done this for so long, is that once we had that initial contact with that first juror, we began going around. We had a list and knocking on, literally on Sundays, knocking on jurors' doors, asking them to speak with us. Some of them wouldn't come out. Some of us told us never to come back. But some did, and some talked to us.
Jurors don't have to talk to you. And when I started out, I would want to talk to jurors after a trial. What did I do wrong? What did I do right? What worked? What didn't work? You know, you get some feedback, and sometimes jurors just don't want to fucking talk to the defense because they had a difficult time with the subject matter or whatever. And on a homicide, you could understand that.
I'll give you an example. And one of the things we heard was once the jury went out, even though there were 6 smokers and they were given smoke breaks during the entire trial, once the jury went out, they were told no more smoke breaks. No, you people that want nicotine, you're going to have to get a verdict first. I mean, it's that kind of stuff. Now that indicates something, and the court would be the one to communicate that. Why? So a bunch of folks told us stuff that appeared to be inconsequential, but in the total context indicated to us that what we've put in this petition about the Cork is credible, and based on sworn testimony from 2 jurors, and we interviewed a third. My paralegal, Holly Miller, has given you an affidavit or filed an affidavit on what she told us. A lot of these folks just don't want to get involved, but they're going to be involved if we get a hearing, because each and every one of them is going to have to testify in an open court before you as to what happened and what didn't happen. Wait, one at a time. Who?
It would appear that Judge Newman was at least aware of some of the allegations that you talk about in your motion. For example, the Facebook post with juror 785, and the judge actually said, "Oh boy, I'm not too pleased about the clerk interrogating a juror as opposed to coming to me and happening to me."
And that's a good point. There's no suggestion that the judge did anything untoward. But what that does do, if it comes back, he may end up being a witness. So, I mean, but until the Court of Appeals acts, that issue does not have to be dealt with.
But if the fact is that the court was aware of some of these issues but still didn't intervene, how concerned are you?
We don't know. We don't know that he didn't intervene. That's what I'm saying. He's a witness. We need to know.
That this evidence is strong enough such that it could have changed the verdict had it been introduced in trial.
So if you heard that question, you know, about if this evidence is strong enough to change the verdict, one of the things, they can't just say there was impropriety going on. It has to be that the impropriety has to be of the kind of nature that could have changed the outcome of the case. I don't know if a statement by the clerk about the defendant's testimony is enough, but it's one of those things where it's so bad that it shocks the conscience that it can't be cured by anything other than a new trial.
The legal test is the subject matter prejudicial to the defense? It's not would it have made a difference in the outcome? Was the subject matter of the improper private conversation material to the defense?
Okay, so it was subject matter material to the defense, not whether it would, not only material, but would it have prejudiced the defense?
If it's immaterial, like what do you want to have for dinner? Do you want to take a smoke break? Do you want to go home? Those are immaterial matters. But when the subject matter is, and is reported under oath by these jurors, it was a direction on how you should receive Alec Murdaugh's testimony. You should look at him. Don't be fooled by him. That subject matter is absolutely material. That's the core of our defense, and that is something that we had no chance to defend against. And so we strongly believe if that evidence is accurate, and the law will require a new trial.
No question about it. If he is 100% right. If the facts come out the way they say, in their motion, then it's going to be game over. And it's not. Sometimes when you have a mistrial, or not a mistrial, but when you have an error like this, maybe it's caused by the prosecution themselves. You can have a complete reversal of the conviction. This reverses the conviction, but you get a new trial.
Well, I can't talk about attorney-client privilege information. I can.
You just said one of the questions was, do you believe that a court clerk should be criminally charged? They wouldn't have referred it to the U.S. Attorney's Office for an investigation if they didn't think she should be criminally charged. And what would the charge be? It would be the deprivation of somebody's constitutional right to a trial. That would be a violation of federal law.
I can tell you that when I shared with him the affidavits, he's a lawyer, he was astonished, he was shaking, he was in disbelief, and he thanked Mr. Harpootlian, Mr. Barber, and myself for spending our weekends on dirt roads in Colleton County.
And by the way, we've seen more of Colleton County on dirt roads in places we're city boys, we didn't believe existed in this state, looking for folks that would talk to us. A lot of doors slammed in our face. A lot of doors slammed in our faces.
You think Ms. Hill should still have her job?
I'm sorry?
You think Ms. Hill should still have her job?
No comment. I'm sorry, what?
That's really smart not to comment on either the potential prosecution or whether she should have her job. You know what they're... I mean, it's kind of a dumb question in a way because you know what their opinion is. I mean, you think she should still be working there even if she, wrote a book and interfered with the jury? Of course not. We're looking at the motion for a new trial. Specifically, during the trial, the Colleton County Clerk of Court, Rebecca Hill, instructed jurors not to be misled by evidence in Murdaugh's defense. She told jurors not to be fooled by Murdaugh's testimony in his own defense. She had frequent private conversations with a jury foreperson, a court-appointed substitution for the foreperson the jury elected for itself at the request of Miss Hill. During the trial, Miss Hill asked jurors for their opinions about Mr. Murdaugh's guilt or innocence. And Miss Hill invented a story about a Facebook post to remove a juror she believed might not vote guilty. Miss Hill pressured the jurors to reach a quick verdict, telling them from the outset of their deliberations that it shouldn't take them long. Miss Hill did these things to secure herself a book deal and media appearances that would not happen in the event of a mistrial. Miss Hill betrayed her oath of office, blah, blah, blah. So this is one of the most concerning things. And this is from Judge Newman himself. After she was dismissed, the other foreperson, Judge Newman said, "Oh boy, I'm not too pleased about a clerk interrogating a juror as opposed to coming to me and bringing this to me." In other words, what she's doing is she's doing her own dirty work and interfering with this jury. If this comes through like this motion says, it's a new trial. There's no question it's a new trial. And then we start all over again. And then we have this whole trial about, with Buster testifying and Pawpaw and the mom, about their murders. By the dad killing his wife and son. And there just isn't any other credible, that I saw, because I watched a lot of that trial, alternative suspect. Now, but it does give them an advantage having tried this case once before. And we'll see what happens. So This is a bombshell. This is kind of shit you don't see, like, ever. I've been practicing half as long, Mr. Tertullian. I mean, I've had 25 years of experience, almost 26 now. And so we'll watch this, and we'll follow it. So we'll continue to follow this. Make sure to subscribe, follow us on Instagram, follow us on Twitter, sign up for Patreon, and we'll see you next time here on Criminal Lawyer Reacts.
Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. Bruce Rivers just broke down your case. He know all the charges that you about to face. You ain't coming home till 2058. That self-snitching gon' get you put away. 23-hour lockdown, police is at my god.